Lesson: Common Law and Civil Law Perspectives on Risk. Common Law and Civil Law Perspectives on Risk. Understanding the nuanced differences between common law and civil law perspectives on risk is essential for professionals involved in contract risk mitigation and compliance. These distinct legal frameworks shape how risk is perceived, allocated, and managed in contractual agreements, influencing compliance strategies and risk mitigation practices. The common law system, prevalent in countries such as the United States and the United Kingdom, relies heavily on case law and judicial precedent. In contrast, civil law systems, found in countries like Germany and France, are based on codified statutes and comprehensive legal codes. Each system offers unique perspectives and tools for addressing risk, providing invaluable insights for enhancing contract risk management strategies. In common law jurisdictions, risk is often allocated through express contractual terms and implied duties derived from judicial precedents. This system emphasizes the autonomy of contracting parties to negotiate the terms of their agreement, allowing for flexibility in risk allocation. A practical tool in this context is the incorporation of risk allocation clauses, such as indemnity clauses, limitation of liability clauses, and force majeure clauses. These clauses can be strategically crafted to manage potential risks by defining the parties' responsibilities and liabilities in specific scenarios. For instance, a limitation of liability clause can cap the amount of damages a party may be required to pay, providing a safeguard against excessive financial exposure. To effectively implement these clauses, professionals must thoroughly analyze past judicial interpretations and precedents to ensure enforceability and alignment with current legal standards. Conversely, in civil law jurisdictions, risk is often addressed through statutory provisions and principles of good faith and fairness. The civil law system emphasizes the role of statutory law and places greater reliance on codified rules and regulations to govern contractual relationships. A practical framework for managing risk in civil law contexts involves conducting a comprehensive legal analysis of applicable statutes and codes to identify mandatory provisions and permissible risk allocation strategies. For example, in Germany, the Civil Code provides specific guidelines for risk allocation in contracts, which must be carefully considered when drafting contractual terms. By leveraging statutory provisions, professionals can ensure compliance with legal requirements while effectively managing contractual risks. A critical aspect of risk management in both common law and civil law systems is the identification and assessment of potential risks. This process involves conducting a thorough risk analysis to identify potential sources of risk and evaluate their likelihood and impact. A practical tool for this purpose is the risk matrix, which provides a visual representation of risks based on their probability and severity. By categorizing risks into low, medium, and high categories, professionals can prioritize their mitigation efforts, focusing on high-impact, high-probability risks. Additionally, scenario analysis can be employed to simulate different risk scenarios and assess the effectiveness of proposed mitigation strategies. This analytical approach allows for the development of robust risk management plans that are tailored to the specific context of the contract and the legal framework in which it operates. Once risks have been identified and assessed, the next step is to implement risk mitigation strategies that align with the legal framework and contractual objectives. In common law jurisdictions, risk mitigation strategies often involve the use of contractual warranties and representations to allocate risk and establish performance standards. A practical approach is to incorporate warranties that specify the quality and performance of goods or services, providing a basis for recourse in the event of non-compliance. For example, a warranty of merchantability can ensure that goods meet a minimum standard of quality, reducing the risk of disputes and financial loss. In civil law jurisdictions, risk mitigation strategies may involve the use of statutory warranties and the doctrine of culpa in contrahendo, which imposes pre-contractual liability for negligent misrepresentations. By leveraging these legal principles, professionals can enhance their risk mitigation efforts and reduce the likelihood of contractual disputes. Effective risk management also requires ongoing monitoring and review of contractual performance and compliance. This involves establishing mechanisms for tracking and assessing compliance with contractual obligations and identifying emerging risks. A practical tool for this purpose is the use of compliance checklists and audit programs, which provide a structured approach to monitoring contractual performance and ensuring adherence to legal and contractual requirements. By conducting regular audits and reviews, professionals can identify potential compliance issues and implement corrective actions to mitigate risks. Additionally, the use of key performance indicators can provide valuable insights into the effectiveness of risk mitigation strategies and inform future risk management decisions. The integration of technology and data analytics into risk management processes is another critical aspect of modern contract risk mitigation strategies. Advanced data analytics tools can provide valuable insights into risk patterns and trends, enabling professionals to make informed decisions and enhance their risk management capabilities. For instance, predictive analytics can be used to forecast potential risks and assess their impact on contractual performance, allowing for proactive risk mitigation measures. Additionally, digital contract management systems can streamline the process of monitoring contractual compliance and managing risk-related documentation, improving efficiency and reducing the likelihood of errors. A real-world example of the application of these principles can be seen in the construction industry, where risk management is a critical component of project success. In a construction project governed by common law principles, the use of detailed contractual clauses to allocate risk and establish performance standards is essential. For instance, a construction contract may include specific provisions for liquidated damages in the event of project delays, providing a clear framework for managing time-related risks. In contrast, a construction project in a civil law jurisdiction may rely more heavily on statutory provisions and principles of good faith to allocate risk and ensure compliance. By understanding the legal framework and leveraging appropriate risk management tools, construction professionals can effectively mitigate risks and enhance project outcomes. In conclusion, the common law and civil law perspectives on risk offer distinct approaches to contract risk mitigation and compliance. By understanding the unique characteristics of each legal framework and leveraging practical tools and frameworks, professionals can enhance their risk management strategies and improve contractual outcomes. The effective identification, assessment, and mitigation of risks are essential components of successful contract management, requiring a comprehensive understanding of legal principles and practical applications. Through ongoing monitoring and the integration of technology, professionals can further enhance their risk management capabilities and ensure compliance with legal and contractual requirements. By adopting a proactive and informed approach to risk management, professionals can navigate the complexities of common law and civil law systems and achieve greater success in contract risk mitigation and compliance.